2 weeks I've been noticing every day the matter is being adjourned.
Only for the day, madam. Monday, madam. Fix for Monday.
Okay, let it be Monday then, because Monday. On the prayer made by Mr. N.G. Kundu, Land Council for the petitioner, the matter is reluctantly adjourned. As this is a review petition of 2018. Based on 8/5/2023. Yes. After matters will be taken up.
Daily list for hearing, item 6 to 7.
Yes.
Earlier occasion, your lawsuits directed to a standing council to bring in notification on which your lawsuit want to see.
Okay, we have that notification. You have the notification.
Here elementary education is there, my lord. All the engaged council are in leg, my lord. So, my lord, after some time, my lord, for the time being, my lord.
Okay. And
Elementary.
My lord, kindly pass over for time being, my lord. Bhar Mazumdar will appear.
Daily list, item 8 with 9.
Right, please, lordship. In this case, record has to be reconstructed. They were directed to reconstruct the record, elementary education. It was for reconstruction of record. Lordship. They played for some time, last occasion.
okay.
Here also, my lord, Bhar Mazumdar.
Okay. After some time.
On 15/6/2006, this approval was given. In fact, my lord, we had to file a contempt petition. At that point of time, one gentleman called Sahu was the director. Now he set over the matter, contempt proceeding was initiated. Only then, my lord, this order was passed. Page 25. Resolution number 4B dated 27/5/2003 of the governing body of the Arjavidyapith College, appointing the following teachers is hereby approved formally, subject to the following terms and conditions. The appointment of the concerned incumbent would be subjected to clearing net slate within 2 years from the date of approval. Until then, she would be treated as a provisioner and liable to be discharged without any notice if she failed to obtain clearance of net and slate within time. The incumbent concerned will get a minimum scale of rupees 8,000 per month during the provisionary period and other allowances as admissible under the rules. So, my lord, what I was paid a scale of mere 8,000 rupees. If the resolution of the governing body is found incorrect, anyway. So, my lord, eventually the approval was given in the year 2006. Now, it is a fact, my lord, in the meantime, on 22-23, that requirement of having net and slate was introduced by UGC and it was accepted by the state, my lord.
22, 23.
20223 at page 26, my lord. This is a sort of a circular, my guideline, my lord, issued by the Director of Higher Education. Phrase guidelines to be followed for selection of candidates for appointment of principal, lecturer, etc. Then, my lord, will kindly come to the right-hand side, B, selection of lecturer at page 407. Selection of lecturer, then my lord will skip over to the next page, page 408. Norms for the post of lecturer, librarian at page 408.
Yes.
Good academic record with at least 55%, no rounding off of marks, and or equivalent grade of B in 7-point scale with letter grades O so and so at master degree level in the relevant subject from an Indian university or an equivalent degree from a foreign university. Besides fulfilling the above qualification, candidates should have cleared eligibility test, that is net or slate. So, my lord, for the first time, the net or slate became a essential requirement only with effect from 28th of February 2003. Now, in the meantime, my lord, petitioner joined. Then my lord will kindly come to page 37. She was drawing that minimum of scale of rupees 8,000. Even now, my lord. Now, of course, recently it has been enhanced, whereas my contemporaries are receiving much more. Now, my lord will kindly come to page 37. In 29th of May 2015, the successor director wrote to the government regarding consideration of incremental benefit in respect of Jyotirupa Sarma. Now, I'll have your lordship's kind attention to third parameter. However, the process of appointment of Sarma was delayed because, no, sorry, I must read the first paragraph. It is mentioned that the said post of lecturer in the Department of Anthropology was advertised in Assam Tribune on 16th of June 98 by the College Authority of Arya Vidyapeeth College, inviting application from candidates having UGC norms, honors, master's degree level. The requirement of eligibility for the post did not include net slate. The interview for the post was held on 4th December 1998. However, the process of appointment of MS Sarma was delayed because of the following reason. The selection committee placed Jyotirupa Sarma in the first position, but the then governing body preferred the second nominee over Mrs. Sarma. And as agreed, Ms. Sarma filed a writ petition in the Honorable Guwahati High Court. The Honorable Guwahati High Court, after perusal of the record, directed Director of Public Instruction shall adhere to the recommendation of the selection committee. On receipt of the judgment and order of the Guwahati High Court, the Director Higher Education instructed principal for compliance of the said order of the court. However, due to non-existence of governing body, the Honorable Guwahati High Court's order could not be honored. Nevertheless, as soon as governing body was reconstituted, it resolved to honor the Honorable Guwahati High Court's order and appointed Jyotirupa Sharma as lecturer in his very first meeting on 27th of May. Kindly see, my lord. 27th of May 2003, college proposed my name and the approval was given on 15th of May 2006. The GB's resolution appointing Jyotirupa Sharma was sent to the DHC for his approval on 16 June 2003. So he was sitting over it, my lord. However, process of appointment of Mrs. Sharma was delayed and therefore Sharma again filed a contempt case. In response to the Honorable Guwahati High Court's order dated 2106, DHC issued an order approving the appointment of Jyotirupa Sharma on 21/106. MS Jyotirupa Sharma thereafter joined as a lecturer in the Department of Anthropology on 1/2/2006. In the meantime, MS Sharma cleared UGC NET held on 30th of June 2013, date of qualifying so and so, so and so. In the meantime, I have also completed my PhD also. Now, therefore, now what is my grievance, my lord? Please come to
Just a moment.
one second.
Yes.
My lord, what is my basic case is a para 11, page 8. In fact, I have challenged that, my lord, approval given by DHC, whereby the requirement of net slate was there, my lord. It is most respectfully stated herein that there was no requirement of net slate in the advertisement dated 6/6/98. Pursuant to the advertisement, the selection process took place in accordance with law, wherein petitioner stood first in the process, and in the entire process, there was no requirement of clearing net slate. That the requirement of net slate recommended by UGC was adopted and made compulsory by the government of Assam by notification dated 22/2003. Therefore, with utmost respect, it is submitted herein that respondent number 3 would not have been imposed the requirement of net slate in the appointment letter dated 15/6/2006, as selection process of petitioner was completed in the year 98. It is reiterated herein that the reason for undue delay of the petitioner's appointment cannot be attributed to her, but solely due to unwarranted action of the respondent authorities. That by imposing the said condition, respondent number 3, by necessary implication, imposed the requirement of net slate retrospectively, which could not have been done unless expressly stated. The aforesaid action of the respondent authorities for reasons other than bona fide with an ulterior motive is definitely not in accordance with law and calls for interference by this honorable court. It is further submitted herein that in the interest of justice, a direction is sought from this honorable court to the respondent authorities to regularize the service of the petitioner from the date of joining, appointment, along with salary increment as per law, and to pay the petitioner her arrears salary from the date of her appointment, along with all consequential service benefit. It is further submitted herein that lecturers working in the sanctioned post of provincialized colleges having UGC norms are drawing much higher pay scale as compared to the petitioner. Lecturers in Ajobidabit College by selection process pursuant to advertisement dated 6/6/98 are at present drawing 6th pay commission salary, but the petitioner is still drawing 5th pay commission salary despite being selected by the selection process pursuant to an advertisement dated 6/6/98 and having all the necessary qualification. That this discrimination on the part of the respondent is violative of law of the land and warrants interference by this honorable court. Equal pay for equal work is well settled proposition principle in law, and in present case in hand, there appears to be a clear violation of the principle. Now, what had happened, my lord? Because that condition was imposed in the 15/6/2006 appointment order, my lord, my still date I am a provisional knight. They have not decided the issue. Whereas the director in 2015 wrote to the government saying, I am not at fault. My lord, I am the first nominee. I am not selected. Sorry, I am not appointed. Somebody else is appointed. I come to the court. Court says no, appoint her. So, my lord, that means you are imposing the requirement of net slate retrospectively. So that can't be done. That is the simple case, my lord. Now, my lord, I did not trouble your lordship with the decisions. I have just brought those decisions, my lord. Now, by what yardstick, my lord, I am being, then subsequently what government did, my lord? Government in between, my lord, they have published a notification on the 4th of November 22, my lord, whereby all this type of lecturers were paid, 55,000 per month as a consolidated pay. In that list, my lord, my name appears at the serial last, my lord. Arya Vidyapith College, Jyotirupal Sharma, Anthropology, 1206 is my date of joining. So my humble submission is, my lord, my service should be regularized, all consequential benefits should be given, and whatever is the area pay, that should be paid to me. And now, my lord, people are enjoying 7th pay commission. When I joined, it was 5th pay commission was, governing the field, my lord. Now it is 7th pay commission. Now, by what yardstick, my lord, all can be attributed to me, my lord? I can only participate in a selection process. So that is the case, my lord. In fact, my lord, subsequent, my lord, the one affidavit in reply was filed. If your lordship would kindly have that, my lord.
Yes.
In that affidavit, my lord, if your lordship reply,
Affidavit in reply.
my lord, it is dated 27th of July 2017. If your lordship would kindly come to page 9.
Yes.
Now, page 9, this Prasanto Kumar Das, now presently he is an associate professor, my lord. Now he was selected by the same selection process. And you see, my lord, the salary they were getting, 37,400 to 67,000. Similarly, at page 10, Sangita Kakoti, they were appointed by the same selection process. On page 11, Ranjan Das. Yes. My lord, one affidavit was filed by DHC on 23/1/2019.
Yes.
If your lordship would kindly come to page 4 of that affidavit. For example, if your lordship will kindly come to serial number 5, Bornali Sharma, my lord. No,
Page number?
Bornali Sharma, serial number 5, History General.
Page number 4.
Page number 4, my lord. Lecturer heading this lecturer appointed against advertisement dated 6/6/98.
Yes.
Have you also got it? It is a document filed by the my lord director. If your lordship would kindly come to serial number 5, my lord.
Yes,
History General Bornali Sharma. She was, her approval was given on 12/10/99, where there was no condition of net slip. Then, my lord, see serial number 6, Rishikesh Borua, no condition of net slip while giving approval. Similarly, serial number 7, 24/4/2008, no condition. Prasanto Kumar Das, serial number 9, no condition. Then Chandrasri Sankakoti Sharma, no condition. Then my lord Sangita Kotoki, no condition. For example, if your lordship will kindly come to page number, my lord. Yes. My lord will kindly come to page 8 of that affidavit. This is one Dr. Bhupali Sharma, physics. This approval was given by the same Dr. Sahu on 6th of May 2008. There is no condition of net slip. My lord, this gentleman Sahu was sitting on my file for 3 years. The successor director has said that. Then if your lordship would kindly come to page number 10, my lord. You know,
just a moment.
Music, Apollo, oh no, it's not that. Sorry. Yes. Sorry, my lord will kindly come to page number 12. It is in vernacular, my lord. It was given, approval was given on 13/10/99. There is no condition of net slip. Then my lord will kindly come to page 13.
Just a moment.
Yes. It is again in vernacular. 7/10/99. No condition in respect of Chandrasri Sankakoti Sharma and Rishikesh Borua.
Just a moment. You are first showing me which page? At page 11.
First is page 11, my lord. No, not 11, sorry. Page 12. Page 12. Srimati Bornali Sharma. It was on 13/10/99. No condition of net slip. Page 12. মহাবিদ্যালয় পৰিচালনা সমিতিৰ প্ৰস্তাৱ নম্বৰ মৰ্মে তলত উল্লেখিত প্ৰবক্তা কলেজৰ কৰ্মচাৰীসকলৰ নিযুক্তি তেওঁলোকৰ নামৰ বিপৰীতে দেখুওৱা পদ যাব লাগিব আৰু বিভাগৰ পৰিচালিত নিয়ম অনুসৰি চৰ্ত সাপেক্ষে অস্থায়ীভাৱে অনুমোদন দিয়া হ'ল। Then my lord will kindly come to page 13. It was on 7/10/99. Same thing. ইমান তাৰিখৰ প্ৰচলিত নিয়ম আৰু চৰ্ত সাপেক্ষে so and so অনুমোদন দিয়া হ'ল, no condition. These are in person to the same advertisement. Similarly, at page 14, my lord, it was on 7/12/99. This is in respect of Prashanto Kumar Das, Pravokta Rajniti Vigyan, no condition. Would not have it, my lord. I'm just I wanted to know, my lord, how you dealt with the cases who are covered by the same advertisement dated 6/6/98. Naturally, my lord, since there was no requirement, since the requirement was envisaged only in February 2003, therefore, merely because by the time I was appointed, my lord, the requirement was envisaged by the UGC, that does not mean, my lord, it can be applied retrospectively. Therefore, my humble prayer is, my lord, in the fit case, your lordship will direct the authority to regularize my services, pay my salary according to the applicable, my lord, pay commission recommendations from time to time, and whatever are the area pay, my lord, that should be paid to me within a time frame, my lord. In fact, my lord, my prayer, as I have indicated, my lord,
That I noted.
at page number 14, my lord.
I have seen that.
Yes. That is my humble prayer, my lord.
Mr. Goy, uh, in this case, you'll have to also answer one point.
Yes, sir.
You see, if one is selected from a select list, any appointment made at any point of time will relate back to that select list.
Yes. I will address.
Okay.
I will address. Yes.
My lord, I'm not troubling your lordship with the judgment.
You can cite because otherwise.
Okay. I'll just give the citations, my lord. I'll give the copy, hand over the copy. My lord, for the proposition that whatever was the, rules or regulations obtaining on the date of advertisement, that will govern the selection, my lord. 2008, 3 SCC 724.
Please give the citation again.
But that Madan Mohan Sharma's case, my lord, 2008, 3 SCC 724, paragraph 11, my lord. I'll give the copy, my lord.
Yes,
The other is, my lord, 1997, 10 SCC 419,
1997.
10 SCC 419. State of Rajasthan versus R. Dayal, para 8, my lord. So these are the two judgments I am citing for the proposition that the requirement of net and slate having been introduced only with effect from 2003. Therefore, you can't apply it to a selection which was done in 1998. If everything was over by December 1990. So that is my humble selection. Deeply.
Yes, Mr. Gogoi.
May please, your lordship. My lord, may straight away kindly come to para portion, lordship. Pair made by the petitioner, lordship.
Yes,
I am starting from lordship last paragraph D, para D, lordship, page 15, lordship.
yes,
The pair made by the petitioner is lordship, mandamus shall not be issued, directing the respondent authorities to grant the petitioner legitimate increment of salary as per law from completing PhD and clearing net, lordship. We have no objection, lordship. In that particular pair, lordship, we have no objection, lordship. Petitioner is entitled from the date of lordship.
No, mic to point.
Oh, of course. Am I audible, lordship? In pair made by the petitioner, pair number D, lordship says petitioner prayed their lordship. She should be given the UGC scale of pay, lordship from the date of acquiring lordship PhD and net and slate. Even lordship, the condition of the appointment also stipulated that lordship she should be acquired net and slate, lordship. We have no objection. She has fulfilled the conditions, lordship, from the date of lordship acquiring net and slate as pair made by the petitioner. We have no objection, lordship.
yes,
Before that, lordship, if petitioner is lordship paying for lordship, that she should be given the UGC UGC scale of pay, lordship, prior to the lordship acquirement of the UGC scale of pay. That part, lordship, I have objection, lordship. If lordship petitioner insists that pair, lordship, then I have no other submission, lordship.
no, he's pressing for the
Ah.
benefit since.
Lordship, then I have
Uh,
the submission, lordship. I have, as per the pair made by the petitioner, lordship, even Honorable Appeals Court also says that, lordship, the Honorable Court, lordship, may entertain the petition on the basis of the pair made by the petitioner. I have placed that particular judgment also, lordship. Although strictly CPC is not followed, but the spirit of the CPC should be followed, lordship. I will place the judgment later on, lordship. Now, for a moment, lordship, kindly come to paragraph page 25, lordship. Page 25, lordship.
Page 25 is the appointment letter of the petitioner, Lordship. Annexure 4, Lordship. The approval of the appointment lecturer, Lordship, as per resolution 4, Lordship, on the following grounds, Lordship. That the conditions is stipulated that, Lordship, the appointment of the concerned incumbent with subject to clearing the net and slate within 2 years from the date of approval. Till then, she should be treated as probationer and liable to be discharged without any notice if she failed to clear and obtaining net and slate within that time, Lordship. And other parties, Lordship, regarding salary, Lordship.
Yes,
Petitioner has accepted that particular conditional appointment, Lordship, and she has joined, Lordship. And she has never challenged, Lordship, that particular condition of appointment, Lordship, prior to filing of this petition in 2016, Lordship. That particular order was issued, Lordship, on 2006, Lordship. 10 years, Lordship, there is no grievance, and she is, Lordship, accepting the condition, Lordship. And in that regard, Lordship, I will place the judgment of the Honorable Apex Court in law laid down in the M. Palanaswamy's case, Lordship. I will place it, Lordship, later on. This is a conditional appointment, Lordship. She has accepted the conditions, Lordship. Now, Lordship, as per my submission, Lordship, she cannot turn around it, Lordship. She cannot, Lordship, challenge it after 10 years, Lordship. So, Lordship, for the first point, Lordship, I am relying M. Palanaswamy's case, Lordship.
I already have it.
Lordship,
Palaniswamy, on that day you placed it.
Lordship, paragraph 30, Lordship, just I am reiterated, Lordship, if Lordship permit, Lordship. If Lordship allowed, I can read 2 paragraphs, Lordship.
Not required, you read it on that day.
Lordship, here
And
also
you-
delay part is also, Lordship, explained by this case.
Okay, okay.
Lordship.
What was the citation? Please give that again.
Citation is, Lordship, 2009 6 SCC 428, Lordship.
Yes.
Paragraph 30, Lordship. It cannot be forgotten that this regulation was all along accepted by the present applicants. Once they chose to accept the regulation, which was conditional, then it would have to be borne in mind that they have accepted the condition also, Lordship. It cannot be countenanced that only the favorable part of the GOMs was accepted by them and the unfavorable part was rejected, Lordship. If they had do so, they had to challenge the GOMs immediately, Lordship, regarding that particular condition, Lordship. They did not do it. Instead, they waited almost for 6 years, Lordship. After 6 years, they have challenged the particular condition. Then Honorable Court, Lordship, Honorable Apex Court finds that now you cannot, Lordship. Here in this case, Lordship, the particular order was issued, Lordship, in 2006, Lordship. They have approached the Honorable Court for the first time in 2016, Lordship. It's about 10 years, Lordship. They did not do it to, instead they waited almost for 6 years when for the first time they came out with an original application that is original application on so and so. Again, when the matters were decided in the writ petition in 1998, the seniority paid for on the basis of the initial appointment was refused to them. They kept quiet only to raise the same demand again on 2003 when the panel was prepared. Here is also, Lordship, issue is not exactly similar, but the law laid down by the Honorable Apex Court is equally covered, Lordship. Here is also conditional appointment. They have approached the Honorable Court after 10 years, Lordship. As per Honorable Court, Honorable Apex Court, Lordship, law laid down by the in Palanaswamy's case, Lordship, that conditions we cannot now waive, Lordship. And paragraph 35 also says that, Lordship. Only 2 lines I have read, Lordship. Without a demur, and if this is not sufficient, they did not challenge it at least for 6 years long. Therefore, up to 2003, all this goes totally against the claim of the applicants, Lordship. This is the ultimate findings of the Honorable Apex Court, Lordship. And another judgment also there, Lordship, 2015 14 SCC 328, Lordship. Surendra Kumar and others, Lordship.
Give the citation again. 2015.
2015 14 SCC 82 Lordship. Just only 2 lines I am reading from paragraph 14 Lordship. Lordship, I have a copy, Lordship.
1984 one is. 1984 one is CC triple two.
Yes,
Lordship, paragraph 14 Lordship, only last 3 lines I am reading Lordship. Paragraph 14. There is a policy decision of the government Lordship. As per the policy decision, certain condition was imposed Lordship, and they were Lordship adjusted or regularized Lordship against the sanction post. Only last 3 lines from the paragraph 14 Lordship.
yes,
Having accepted in internal page 388 Lordship.
yes,
Having accepted the appointment orders dated so and also joined the post, the appellants cannot turn down and claim regulation with respective effect Lordship. There is a condition stipulated that Lordship, they should not Lordship claim for the retrospective regulation Lordship.
yes,
In respect of paragraph 11 of the repetition Lordship. Before that Lordship, paragraph 14
just a moment.
Lordship. Lordship, paragraph 14.
Yes, this Surendra Kumar.
No, Lordship, paragraph 14 from the repetition.
Oh, repetition.
Paragraph 14 is Lordship relates to pair made the petitioner in respect of pair D Lordship.
Yes,
Here Lordship, it is humbly stated that Principal Idaho Vidyapith College by letter dated so and so to respondent of T intimated for consideration of an incremental benefit in respect to the petitioner that since petitioner have cleared net, the respondent of who by appropriate letter intimated that respondent number T that the condition of clear net and slate in the appointment letter issued by the respondent number T with the petitioner is fulfilled, though not within the prescribed time period of 2 years. Therefore, by the said letter, it was intimated to the respondent number 3 for necessary action Lordship. If Lordships, as per the Lordship, the averments made by the petitioner Lordship, if it is covered by the paragraph D Lordship. In that respect, Lordship, we have no objection Lordship. Although she has not completed within the stipulated period of time Lordship, now she is acquired the UGC's required qualification Lordship. So she is entitled from the date of acquiring the qualification Lordship. Regarding paragraph 11 Lordship.
yes,
Well, Lordship, I point out another regarding conditional appointment, another judgment also, one of the latest judgment of the Honorable Appeals Court Lordship. In 2021, Honorable Apex Court decide the issue, Lordship. The conditional appointment can be challenged, Lordship. Even Lordship, when it was petitioners think that he is aggrieved by that condition, Lordship, on the condition that, Lordship, if that particular condition was imposed, Lordship, by violating the rules and regulations, Lordship. It is 2021 judgment, Lordship. If Lordship required, I can place the citation also, Lordship. Conditional appointment can be challenged if it is put by violation of the, Lordship, that's rules and regulations, Lordship.
What is that?
Lordship. It's a citation, Lordship, 2021 10 SCC 116, Lordship.
2021.
2021 10 SCC, Lordship, 116, Lordship. If Lordship permit, I can read one paragraph, Lordship.
Yes.
In paragraph 43, it says that, Lordship, the bargaining power is vested to the employer itself and the employee is left with no option but to accept the condition dictated by the authority. If that being the reason, it is open for the employee to challenge the condition if it is not being in conformity with the statutory requirements under the law, Lordship. Then she can challenge. We can fare before the honorable courts when we have to argue, Lordship. So I have pointed out this also, Lordship, because if, Lordship, we impose that particular conditions, Lordship, by violating the, Lordship, rules and regulations, Lordship, that then any state petitioner can challenge it, Lordship. There is no bar as per the latest honorable Apex Court, Lordship, judgment, Lordship. Here in our case, Lordship, it is a totally defined footing, Lordship. The condition stipulated in the appointment letter is, Lordship, as per the statutory mandate, Lordship, as per the UGC's regulations, Lordship, which was adopted by the State of Assam, and, Lordship, the Ministry of Human Resource Development, Lordship, guidelines, Lordship, which was also adopted by the State of Assam from long back, Lordship. It will be reflected from the OM dated 2004, Lordship. I will place it, Lordship. Now, Lordship, paragraph 11 of the writ petition, Lordship.
Yes.
Lordship. It is most respectfully stated herein that there was no requirement of net and slate in the advertisement dated so and so. Pursuant to the advertisement, the selection process took place in accordance with the law. When the petitioner stood fast in possesses the entire process, there is no requirement of the clearing net and slate. The requirement net and slate recommended by the UCC was adopted and made compulsory by the government of Assam by notification dated 22/2003. My lord, may kindly mark it. That this part. Lordship,
Yes.
Lordship, may
You complete your part.
Lordship,
This
Lord.
part you complete.
Lordship, Lordship,
This part.
Lordship.
Hmm.
20, as per the amendments made by the petitioner, Lordship, it was made mandatory from 22/2003, Lordship. It is not correct, Lordship, because that particular OM was issued is itself, Lordship, in 1998 UCC regulation is there. Before that 1991 is there. Before that 1987 Lordship human resource guideline is there, Lordship. All are following by the government of Assam, Lordship. Even, Lordship, 2002 to 2003, before that 2000 OM also there, Lordship. I will place everything, Lordship.
You refer to 1998 OM on that day.
Lordship,
I could not trace out. You have a copy of that?
Lordship, I will place it.
Okay.
1990, even 1991 is also there, Lordship. I'll
No,
place it.
91 will not be applicable. It will be 98 would be applicable.
Even from 1987 onwards, Lordship, it is continuation. And even, Lordship, the 2004 OM itself, Lordship, mentioned the 1987 human resource guideline. Lordship.
Okay, please that because I did not, I tried to search, I didn't get it.
Lordship, I will provide.
Pick up, they can come back.
This case in Mahamud submission, the selection was done, and that is being challenged here by the second read of the petitioner. And in Mahamud submission, since the order itself states that the regarding Milord 5209. Your Lordship has seen the order that is being challenged here. At page 62, challenging her provincialization. There, the condition 4 states clearly that if any that matter is pending relating to this issue, in case of the school having any court case in connection with the appointment of teacher, the court case was relating to her appointment only, her case only. So in that case, this could not have been done. So in view of that fact, my lord, my submission will be that let this order be cancelled or suspended, and the matter referred back to the Director of Elementary Education for reconsideration. And in that case, my lord, the question that she was serving, she was having dual service while serving as a teacher. My learned friend has tried to show that it does not clash. Whether it clashes or not, it is different, but she was taking money. That is more important. Because I mentioned earlier also.
No, but the fact remains that at that time it was a venture institution, whether this will apply or not.
No, venture institution, but from 9 million, there was financial help, assistance. Under the state government scheme, million, financial assistance was given.
What was the financial assistance?
The lump sum amount is given yearly, and that is being distributed by the teachers for the management. And that way, 9, 10, and 11, only in 11 June, she resigned. So in these 2 years, she accepted that money.
No. You see, acceptance of money, let us say, for an example, X is doing a very good work. He has this, let us say, Ladasil Welfare Committee. He is doing a very good work. He is given a lump sum amount by the government for doing good work. That doesn't make him a government servant. Because you see, our judgments have held in many matters that the service of this Anganwadi worker, they are not civil posts. It is not covered by this, as you are in this disciplinary service appeal rules, it's not covered by this 2E.
No, but as a teacher, below.
Teacher was also a venture stage then.
Venture stage there. That's true.
Because if X does a tuition, he gets money. It doesn't make him a government servant. And Mr. Datta has demonstrated that on the when the order was received, he relinquished the service in Anganwadi Center.
My lord.
Mr. Datta has demonstrated that once he got a permanent service, he relinquished the service of Anganwadi helper.
In fact, when the financial assistance was granted, my lord, I immediately resigned from the Anganwadi. Not even my lord, government service, my lord. When the financial assistance was given in May 2011, in June 2011, my lord, having
In
learned,
11, she resigned.
immediately I resigned. my lord.
In 11, she resigned. That is true. But in view of this predicament, my lord, at page 62 of this case, my lord,
Yes, that during the court case could not have been appointed.
Yes. So for that reason, my lord, let the matter go back. They will reconsider.
Okay. Yes, Mr. Datta.
My lord.
These are my submission.
Lord, therefore, my lord, I have since the submission that I was making, my lord, there is one side of it, which is the technical side. The other side, my lord, is the substantive part of it. Whether, my lord, I could have been a lot debut from my lord provincialization. That is the first issue, my lord, because of the two my lord, services I was rendering. My case is that, my lord, I was working as the Anganwadi helper, as well as in the venture school, but there was no clash of, my lord, the schedule, because it was for the same campus. It couldn't have. Therefore, in the morning hours, I used to discharge my duties as Anganwadi worker, helper. And when the school starts at 10 or 10:30, I used to serve as a venture education venture teacher. Now, so far the timings are concerned, my lord, these timings came to be notified in 2011 only, my lord. Before that, there was no timing, in fact, notified for the centers. And the government, in order to
Just a
start.
moment, just.
My lord.
Yes,
My lord, page 10, my lord, is the my lord of WPC in my affair in opposition, my lord. In my lord WPC number 5209 of 2016. My lord, it was a notification dated 26th of May 2011. And that is for the first time, my lord, I claim, my lord, and that on this
page,
page, my lord, 10 of my affidavit. Got you correct, my lord?
yes,
26th of May 2011. It's a typed copy, my lord. The photocopy also I have annexed, my lord. Since it's not clear, I have typed it out. Lordship will see, my lord, this is for the first time. In fact, if Lordship looks at the circular, it indicates, my lord, this is, my lord, streamlining of the process. This is it's for the general information of all concerned that the timing of Anganwadi centers with permanent building, my lord, and Anganwadi centers in club building premises under the ICDS scheme. So this was only that too only for, my lord, for the purpose of, my lord, those having, my lord, permanent buildings and Anganwadi centers in, my lord, club and building premises of the, my lord, ICDS scheme, my lord, not otherwise. In the state of Assam, as per the guidelines of India, Government of India have been fixed as shown below for maintaining the uniformity in the time schedule of the daily activities, as well as the periodic activities by the Anganwadi centers with immediate effect. So there, my lord, from then on, my lord, with regard to these structure, my lord, centers having permanent buildings, only, my lord, this time frame was brought into force. That is in May 2011. And in June 2011, as I've stated, my lord, I had already resigned. So therefore, my lord, my case is that when I was working as the Anganwadi worker, my lord, helper rather, it was from the same, it was from the school campus, not from a permanent building. And in the same campus, my lord, the Anganwadi center used to work in the morning, and after, my lord, the school starts, my lord, the school is to run. That is how it functioned, and that is how I discharge my duties. And, my lord, on the point, my lord, Lordship has already, my lord, rightly appreciated, my lord, that Anganwadi workers and helpers and workers are not, my lord, civil post holders, and that has been, my lord, held by the Supreme Court also, my lord, in the case of state of Karnataka versus Amir B. That is, my lord, reported in, my lord, 2007-11 SCC 681, as well as when AR online 2006, my lord, 648.
2000,
Lord, 2011, 11 SCC 681, and, my lord, AIR online 2006 SC 648. Here, my lord, various aspects were taken into consideration, my lord. And my lord, lastly, in paragraph, my lord, the last page, my lord, in fact, in the paragraph, my lord, 29, sorry, my lord, sorry, 33, my lord, 33, the last page. We are concerned herein with only one question, namely, whether the respondents are holders of any civil posts. We are having regard to the materials on record of the
We are reading where?
that they are not. Page 33, my lord, last page, my lord. So page, my lord, sorry, paragraph 33, last page, page 11, my lord.
Yes,
Yes, my lord. Last finding, my lord. This is with regard to, my lord, the Anganwadi workers and helpers, my lord. This
yes.
would be evident from the fact, my lord. We are concerned herein with only one question, whether the respondents are holders of any civil posts. We are having regard to the materials on record of the view, they are not. So, my lord, it has been clearly held by the Supreme Court also, my lord, that Anganwadi workers and helpers, my lord, are not, my lord, civil post holders. So, my lord, and as your lordship has already, my lord, rightly appreciated, my lord, that I was a venture education, my lord, institution teacher. And my lord, though my learned senior has, my lord, said that from 2009 financial assistance was being granted. But my lord, in my lord state affidavit, I have specifically stated it was given from May 2011. And in June 2011, my lord, I resigned from the post of Anganwadi helper. So I was not serving, my lord, when this financial assistance was being granted to the school. My lord, I resigned immediately, my lord, and I started concentrating as a teacher only, my lord, and left the other, my lord, job, my lord. In any case, my lord, that not being neither of the posts being civil posts, my lord. And my lord, in fact, not even substantive appointments, permanent appointments under the government. Therefore, my lord, substantively, my lord, there was no bar for my provincialization. And that is the basic reason, my lord, why, my lord, my case was, my lord, sought to be, my lord, disturbed by the school authorities. My lord, so far as the other part is concerned, with regard to, my lord, the judgment of this honorable court in the earlier writ petition, my lord, lordship perhaps has also brought this, that has been brought on record, the earlier writ petition, my lord. The prayer was with regard to, my lord, the resolution by which, my lord, I was downgraded and she was upgraded or promoted, my lord. There, my lord, that was the challenge. And in that context, this honorable court, my lord, on the submission of the, my lord, learned counsel for the education department, my lord, he, my lord, made a statement, my lord, that there is a district level redressal committee and the state level committee. And accordingly, my lord, the matter was referred to the district level committee. In terms of the notification, my lord, dated 30, my lord, 1/2013. Now that notification has been produced by my learned friend today. Well, that notification I find, my lord, is totally in a different context altogether. That notification, my lord, is on the issue of provincialization of the schools, my lord, not on individual cases. It's very clear from the, my lord, notification itself. And secondly, my lord, this is not under the, my lord, the section 10 of the, my lord, Provincialization Act 2011. That will come, that will also I'll refer, my lord. Section 10, my lord. This notification, my lord, 30th of January 2013. It reads, my lord, that the governor.
Just a moment.
Page 6 and 7.
Yes,
Well, this notification reads, the governor of Assam is pleased to constitute the grievance redressal committees in both state and district level, excluding the 6 scheduled areas of districts to address the grievances with regard to application for provincialization, financial assistance from government, including of allotment of Dias code and change correction of management authority as shown in the Dias records with the following members. So this is basically, my lord, with regard to the schools, my lord, as a whole, not to individual cases. Because, my lord, lordship will also see, my lord, the terms of references. The terms of references have to come from the head of the institutions, my lord. So what happens, my lord, if someone, my lord, if some school is left out either from provincialization or from financial assistance, my lord, or there is something wrong with the, my lord, allotment of Dias code or change in correction of the management authority as in the Dias records, my lord. It's only then, my lord, when the head of the institution makes a reference, my lord, the dispute redressal committee comes into, my lord, invokes its jurisdiction and decides the issue. And, my lord, which can also be carried to the state level authority. Here, this particular case, my lord, which was before lordship, my lord, in the earlier round of litigation, the issue was not of provincialization. Issue was more with regard to the downgradation and upgradation of both of us. While she was upgraded, as I was downgraded. Now, pursuant to that, only that direction was issued by this honorable court. And, my lord, in fact, after that direction was issued, on 29th of January 2015, lordship will find that in WPC number 1177 of 2015, annexure 14. The Deputy Director of Elementary Education has passed an order, my lord, by which it was held that, my lord, that
Which page?
page, my lord, 46, my lord, annexure 14 of WPC number 1177. The order of this honorable court was issued in 2013, my lord. And this is in reference to that case only, my lord. WPC number 361 of 2013.
Yes.
With reference to subject cited above, I am directed to inform you that the matter of the petitioner in WPC number so-and-so cannot be considered as she has been working as AWC under Social Welfare Department, and the matter of Ismail Ali Sheikh cannot also be considered as the school managing committee as a school of the school has no power to promote or degrade any one of the teaching or non-teaching staff after 1/1/2011 as per the Venture Education Institutions Provincialization Act 2011. So, my lord, this was what was put under challenge in this writ petition number, my lord, 1177 of 2015. Now, my lord, so far as the, my lord, the district scrutiny committee is concerned, my lord, which, my lord, recommended my case. That, my lord, I have brought in my affidavit, my lord, along with my affidavit. That I have brought on record, my lord. This is an order, my lord, passed for with regard to the provincialization. This is, my lord, a recommendation to the district level scrutiny committee, my lord. So, district scrutiny committee, rather, my lord. My lord, this is a statutory body, my lord. So, for the other, my lord, notification, as I've stated, my lordship, my lord, that notification was not issued under any statute. And, my lord, it is under the Provincialization Act 2011, under section 10, my lord. It is only the district scrutiny committee which has been, my lord, empowered.
Which page?
Page, my lord, 658. There shall be one district scrutiny committee in each district separately for elementary, secondary, and for higher education to scrutinize service records and various and other related issues of the serving teachers of staffs and venture education institutions pertaining to provincialization of their services. So, my lord, this is the authority under law, my lord, which is empowered to, my lord, look into the cases of individual cases of provincialization. Therefore, my lord, this committee, my lord, decision which is this committee had taken, my lord, which is, my lord, in my affidavit, my lord, at page 19, is by a committee, my lord, which is having the jurisdictional authority under the statute, my lord, to decide particularly the cases of provincialization. My lord, and this committee comes to a specific finding, my lord, that the head teacher of the school has been misleading in the management as well as, my lord, the department. In paragraph, last but 3 paragraphs, my lord, he has stated, my lord.
Which page?
Page 19, my lord.
Of which writ petition?
My lord, my affidavit, my lord. Affidavit 5209, my lord, filed by Saleh Khatun on 25/11/2016, my lord. Well, this was
Page-
referred by the
page-
director, my lord.
Page,
Page 19, my lord.
19.
19. Because you will find the resolution, my lord. It starts with peruse the letter issued by DEE Assam by memo number so-and-so dated 9th March 2016 in relation to WPC number 361/2013 dated 12/12/2013. Well, so therefore, this, my lord, letter was issued by the director, taking into account, my lord, the earlier directions also, my lord. The DSC has also examined the statement of the petitioner, the response number 67A, recorded at the time of hearing held on 7/1/2014, in compliance with the Honorable High Court's order. The DSC also perused and examined other relevant records and documents of Balasi VLP school. The matter under examination was relating to wrong upgradation of the response number 8, Ismail Ali Hussain, third assistant teacher to the post of second assistant teacher in place of Saleha Khatun by resolution of the school managing committee dated 21/12/2012, 22/11/2012. It is seen through the records that the head teacher of the school has misled the SMC as well as the department and has made disputed the matter to the petitioner. But the petitioner Srimati Saleha Khatun is serving in the said school. As per the school records and statements of the petitioner and the response number 6, 7, and 8, it is seen that Srimati Saleha Khatun is the first assistant teacher of Balasi VLP school, and the DSC Dhubri has already proposed her name for provincialization of service under the so-and-so Act. Hence, the DSC Dhubri resolved to propose the name of Saleha Khatun as assistant teacher of the Balasi school VLP school for provincialization under the above mentioned 2011 Act. The DSC is requested, the DSC Dhubri requested the DEO member secretary to submit the proposal as per the Honorable High Court's order, so-and-so, and above letter to the higher authority. Now, my lord, this is the committee, my lord, which has the jurisdictional, my lord, authority. Now, my lord, since, my lord, I was submitting, my lord, the primary issue, if the primary, my lord, issue is that whether I can hold the post of, my lord, or whether I'm entitled to provincialization is decided in my favor. There being no bar, my lord, that since I was not holding any civil post for my provincialization. My lord, the second aspect of the matter, whether, my lord, this committee or that committee ought to have considered, my lord, becomes a very technical issue, number one. Secondly, my lord, whether this order could have been passed during the pendency of the repetition because of the, my lord, provision in the page 82, which my learned senior friend has pointed, my lord. They're very technical issues, my lord. Will they substantively alter my position, my lord? Now, as I've said, my lord, unless there is a jurisdictional error, the scrutiny committee is the authority under law, my lord, which has been constituted as per, my lord, the Act, my lord. That scrutiny committee has, my lord, looked into all the cases of provincialization, irrespective of, my lord, whether there is a dispute or not. And thereafter, on the recommendation of this committee's report, my lord, the matter is taken up before the higher authorities or the director, my lord, and it is decided thereupon. If they find there is something wrong with the, my lord, recommendation, of course, these recommendations are altered also. That's a different issue. But here, both of them concurred. The director, on the basis of this, my lord, district scrutiny committee report, which is the, my lord, jurisdictional committee, my lord, in terms of the Act, my lord, has given this report. Now, if lordship has already comes to a finding, my lord, that this there was no bar for provincialization of the petitioner, my lord, I, being the senior most petitioner, my lord, could not have been, my lord, demoted because I was an Anganwadi worker also by the school managing committee, because that they could not have done. And that being the position, my lord, seniority being one of the criteria under 2011 Act, if I'm entitled to provincialization, my lord, remanding of the back of the matter, my lord, will only, my lord, be by a different committee. Will only be a very technical, my lord, kind of a thing, my lord, which, my lord, will only, my lord, create complications because of the, my lord, more so because of, my lord, the eclipse of them, or, my lord, setting aside of the earlier Act, my lord, having been repealed. So therefore, my lord, substantively, my lord,
you are covered by the earlier 2011.
No, no.
2011 Act.
Yes, my lord. Because 2011 Act, I was appointed 2011 Act, my lord. Before this Act was repealed, my lord. Or, my lord, it was, my lord,
2011 Act is at which page?
Page, my lord, 650, my lord, it starts, my lord, at page 650, 647, my lord. I was referring to 658, my lord, at district level committee, my lord.
Page 600,
647 it starts.
47.
In fact, my lord, there is a dimming provision, my lord.
Yes, where?
Well, employees to be government servant, my lord, page 4, my lord, 653, my lord, Section 4.
653.
section 4. The services of employees of all eligible venture education institutions under section 3 shall be deemed to have been provincialized on the date of coming into force of this act, and they shall become employees of the state government with effect from that date, provided such institutions have completed at least 7 years of imparting education from the date of affiliation, recognition, concurrence, or permission, as the case may be, as on the date of coming into force of this act. So, my lord, in a way, my lord, this shows, my lord, that once this act has come into force, and if that person is eligible, he is deemed to be, my lord, a employee of the state government. And my lord, since, my lord, I was regularized, my lord, I was provincialized, and this act, now this act has gone, my lord. If your lordship remands back the matter, my lord, only because of the technical reasons, my lord, perhaps, my lord, it will, my lord, cause, my lord, irreparable loss and injury to the petitioner, my lord, because he will now the situation has changed a little, my lord. His provincialization will be under totally, my lord, different act, my lord, and in fact the provisions are also different. So therefore, my lord, once, my lord, if your lordship holds once, and if your lordship holds, my lord, that there was no bar for the petitioner, my lord, to continue in both the posts before it was provincialized, my lord, or before it was even, my lord, when it was on the venture stage, and my lord, as an Anganwadi worker, my lord, then, my lord, sending or remanding back the matter, my lord, for a fresh decision on this issue will only, my lord, delay the matter, but will not change, my lord, substantively, my lord, the outcome of, my lord, the provincialization of the petitioner, my lord. But having said that, my lord, since the earlier act has been repealed, it would cause me, my lord, irreparable loss and injury. And, my lord, so far as that contention, my lord, that with regard to, my lord, that the condition, my lord, that is there, my lord, with regard to non-provincialization of, if there is in dispute, my lord, that is, my lord, basically a kind of, my lord, directory kind of, my lord, my lord, approach, or, my lord, condition that is there in the, my lord, order, to ensure, my lord, that what happens, my lord, if there is if the disputed person is promoted, my lord, and suppose tomorrow his job is taken away, then there is a question of non-payment of salary, etc., or, my lord, regulation, other person comes in, so these difficulties might arise. But here, my lord, if your lordship holds, my lord, that no, there is nothing wrong in the provincialization, or the petitioner is entitled to be provincialized, or was entitled to be provincialized in the earlier act, my lord, remanding the back the matter, my lord, will be, my lord, on the way to will be too technical, my lord, and, my lord, I will just rely upon one judgment, my lord, where, my lord, of this honorable, of the Honorable Apex Court, my lord, in 1994 Supreme Court 1699. AIR 1994 Supreme Court 1699. Here, of course, my lord, it was with regard to a civil dispute, my lord. But then, my lord, the
Yeah, 1994 Supreme Court.
Supreme Court, my lord, 1699, my lord. Raman Kupti Guptan versus Avaria, AVRY. Here, just read, my lord, 2 lines from paragraph, my lord, 6, my lord, at page 4.
Yes.
It is to be seen, my lord, last 3-4 lines, my lord, page 4, my lord, paragraph 6, my lord, it's my lord, the paragraph number is in the earlier page, my lord, but, my lord, last but 3 paragraphs, my lord, last 4 lines, my lord. It is to be seen that the procedure is the handmaid of justice, and unless the procedure touches upon jurisdictional issue, it should be molded to subserve substantial justice. Therefore, technicalities would not stand in the way of to subserve substantial justice. So therefore, my humble submission is, my lord, that since the jurisdictional authority or jurisdictional committee, my lord, is the district scrutiny committee, my lord, So there is no jurisdictional error as such.
I don't know, we must read this in the context. Because in this judgment, I think instead of jurisdiction X, it was under jurisdiction Y,
Why, my lord?
which was adjudicated, and it
Yes.
says that substantial.
Yes, my lord. Here also, my lord, since the jurisdictional committee is the scrutiny committee, my lord, though there was an order, my lord, with regard to, of course, a different subject matter. Even if I consider, my lord, this subject matter has got some overlapping, my lord,
Okay.
then also, my lord, since this is the committee, my lord, this has to go to this committee. Once again, if your lordship, my lord, sends it, it has to go to this particular committee only. It cannot go to any other committee. So therefore, my lord, that order was passed on the submission made by the London Council, my lord, that there is a district level committee. And as I've shown, my lord, that district level committee is only different context altogether. That is with regard to provincialization or diascore disputes of the schools, not with regard to the individual cases. So therefore, my lord, this particular jurisdictional authority of the district level scrutiny committee, my lord, is a which is the jurisdictional authority has passed this order. Therefore, this is a case where the procedure is not touching upon the jurisdictional issue, my lord. In fact, it is the right committee which has decided, and therefore, my lord, and if your lordship holds that, my lord, I am entitled to the post, my lord, then sending back the matter will only, my lord, be a technicality, my lord, which will, my lord, and therefore, my lord, technicalities, my lord, should not stand in the way of substantive justice, my lord. That is my submission. Deputy Lord, my lordship.
Yes, Mr. Bora.
I mean, just one more thing, my lord, just my the point of the learned, the director has filed an affidavit, my lord, saying that, my lord, the committee has recommended my name, my lord, and my lord, as according to the provincialization has been done. So he is not disputing, my lord, my provincialization, my lord, or my lord, my entitlement, my lord.
My only problem is that, my lord, his provincial name was recommended under the whole act, my lord, which is not in force, my lord. My lord, his provincialization order was conditional. No provincialization, my lord, it is stated as no provincialization order will be effected in case of the school having any court cases in connection with the appointment of teachers, my lord. And one judgment passed by this honorable court in a division bench, my lord, Purnavati Brahma, my lord. Here, my lord, division bench hold that. May I read that? My lord, here, we are conscious of the fact that subsequently Assam Education Provincial Service Teachers of Reorganization Education Institution Act 2017, for short, the Act of 2000 was brought in place with effect from 11 April 2017. In the impugned order passed by the single judge, it has been said that no writ of mandamus can be issued in view of the fact that the Act of 2011 is not in force. However, liberty was given to the writ petitioner appellant to approach the appropriate educational tribunal for consideration of her case for provincialization as per law in force. The respondents for the education department were also asked to consider case of the writ petitioner for provincialization under the Act of 2017. If she is entitled for the same in terms of the provision of the 2017. And my lord, here, my lord, since the Act of 2011 was held unconstitutionally invalid as noted above, we find no reason to differ with the key views taken by the learned singles. Well, here my only submission is that since the 2011 Act is not in force, my lord, so lordship, my lord, to direct the petitioners and respondent to approach the authority to pass reason order after hearing the parties as per the new Act, my lord, 2017 Act, which is in force, my lord.
What is that, Purnavati? What is the citation?
W writ appeal number 283 of 2019, man.
Decided on?
Decided on, my lord, date of judgment 13/11/2019.
This is reported, I think.
My lord, I have not gone for the
Okay.
GLT, my lord.
Okay,
Passed by-
spell out the name of the parties,
Parties Purnavati Brahma, Srimati
Spelling,
Purnavati Brahma versus
spelling.
PURNA BATI BRASMA Brahma versus the state of Assam and 6 others. Writ appeal number 283 of 2019.
19. Yes, I have not done. Okay.
Just one thing, I just like to submit here. This judgment is a totally different context altogether. The case of the petitioner was totally different. Here, it was not a case where it was earlier provincialized and therefore thereafter, my lord, there was some, my lord, stay order or.
So this is an authority on the point that it will be under new act.
My lord, no,
Whatever is now
is
decided
not-
will be under the new act.
this is an authority because it was a case of fresh consideration of provincialization, not over the old case matter. Here, the case was, my lord, that are required to provide teachers in Assamese language in every school. The law has been violated.
No,
It's a-
once there is a dispute,
Well-
then it will be the new act which will prevail.
No, but
Now the fresh decision can't be taken under the old act.
no, my submission would be, well, since the order of provincialization is already passed. Had it not been passed, perhaps things would have been different, my lord. Then perhaps it would be not under the
No,
new
if
act.
the old act, you see, what has happened is the old act has been struck down as ultra vires. So therefore, it will be as if there was no act.
No, but it had also, my lord, protected, my lord, those acts which had already done, my lord. So therefore,
Now, if it is a fresh consideration, you are not saved by the saving clause. Under the principles of interpretation, you are not saved.
my lord,
If you can only be saved if I do not accept the challenge of Mr. Salia, then you are saved. But if it is, but you accept his submissions,
Right.
then the fresh consideration would only be under the new act.
my lord, fresh considerations, my lord, that's what I'm saying, my lord. That's giving provision was also there, my lord. Once the provincialization, my lord, took place, my lord, the order was passed, my lord. The order has already passed. Had it been a case, my lord, where the order had not been
No,
passed, perhaps
this
it was
will not be acceptable because of a simple reason.
Right.
Because if I am to send back,
my lord.
then whatever order is there has to be set aside and then only it can be sent back.
Naturally.
The order can't be saved and sent back.
No, if your lordship sends it back. That's what I'm saying. If my lordship holds, my lord, that I'm entitled to the post, my lord. Then, my lord, and the provincial has already been done, my lord. There is no
It
question
is-
of sending it back, my lord.
Provisional
Then-
and
then-
conditional, my lord.
What my learned friend is submitting is not on the basis of the records, my lord, not an affidavit, but the stand of the directorate, my lord. My lord, what my learned friend is submitting, my lord, is not reflected in the stand of the government, my lord. The government has nowhere said, my lord, that we cannot, that this provincialization order is not valid. It's with a clear affidavit, my lord. The question is,
No,
my
no,
lord,
no.
but
His
law is
submissions I have
clear.
understood.
Fine.
The context in which the argument is being made, I have understood.
so
He's
therefore-
simply reminding me that if I intend to send it back,
My lord.
it has to be under the new act. That is the only intention of Mr. Boran.
No, if it is sent back, that's what I'm saying, my lord. Sending back, my lord, on technical ground, my lord, will only, my lord, that is the reason, that's what I was saying, my lord. If it is sent on technical grounds, my lord, then, my lord, my case will have to be considered a new act, my lord. Then there's a problem. But if your lordship decides, my lord, that my provincialization at that point of time was okay, my lord, right? And I couldn't have been debarred, my lord, then, my lord, there is no question of sending it back, my lord. And my lord, my humble submission is, my lord, if substantively your lordship holds that, yes, being an Anganbadi worker and helper or a helper and a teacher at the same time was no bar for me to be provincialized. And the provincialization order or the scrutiny committee's report was rightly done. Then, my lord, the question of remand back doesn't come. And then, my lord, this holds up, the order holds up in. But of course, if your lordship sends it back, of course, there's a question. And therefore, my submission is, my lord, if on the technical grounds, if your lordship sends it back, my lord, it will only cause me irreparable loss and injury because otherwise the petitioner is not going to get any benefit out of it. Even today, my lord, it's fresh consideration, my lord, if your lordship in the basis of those facts, my lord, that I can hold both the posts, my lord, a fresh consideration is done, my lord, I will get the job, but only with, my lord, some changes, my lord, in my service condition, my lord. That will be prejudicial. That is my submission.
I'll pass the order today. To be released only on Monday.
My lord.
Tomorrow being a holiday, I will be able to release it.
Deeply acknowledged.
God bless you.
Just record the names. Mr.
Only
D.P.
I-
Sadia.
My learned friend has already referred to read two decisions, my lord, when the court even say, final order cannot be passed.
Yes.
The references I had already submitted. my lord. One is 2014 for GL.
2014 4 GLT 55
55.
and 2016 5 GLT 187.
Yeah. And there's a single instance. Both are. And the your lordship has seen in the order itself that when they themselves have stated. When there is a court case, final order cannot be accessed. So in view of that, you know, I leave the matter to your.
You've given that citation.
My lord.
You've given a photocopy of that
Yes, my
citation.
lord, yes, my lord. Copies have been given.
I'll just check up because there's
On the
some
last occasion, it was given.
this tab I have given for
Also,
registry. No, I'll just check up. I'll just check up. If it is there, you need not give it again.
I'll send you copies. to you.
No, if I have it, you don't need to send it again.
My lord, there is another judgment from Supreme Court, my learned friend K. Google will point out. Regarding
Just a moment.
I'm giving copies because I have extra.
Please give it because I don't have it right now.
Yes. Yes.
Okay. Monday, this citations, you can take it back. and Return it.
Also, regarding the stuck down issue, Lordship, my friend has pointed out, Lordship. This was also, Lordship, in the another judgment of Honorable Apex Court, it is clarified, Lordship, but only one paragraph, my lord may. This came from the Lordship, state of Manipur, Lordship. Regarding Lordship, the secretary's matter, Lordship, then it was came before the paragraph 18, Lordship may clarify everything, Lordship, whether we can act upon the stuck down act or not, Lordship. In respect of parliamentary secretary, Lordship, that matter was came up before the Apex Court, Lordship. It was negated by the Lordship, Honorable Manipur High Court, then it was paragraph 18 clarifies everything, Lordship.
It doesn't exist.
Lordship,
The law does not exist.
Lordship.
For all purposes, it doesn't exist.
Lordship, paragraph 18 very specific, Lordship. Very, even other judgment also discussed in this case, Lordship.
Now, at the Supreme Court website, there is a window for accessing the Supreme Court and High Court judgments.
Lordship.
So now lawyers need not what you call subscribe to SCC or everything.
Free of cost.
Neutral citations will be now available.
Lordship. Even Lordship, Honorable Kerala High Court also adopted that policy. Before Supreme Court, Kerala High Court introduced.
We are also in process of doing it.
Lordship.
Shall we help?
We need certain what you call, because we don't have manpower. Technical manpower is not with us.
Infrastructure will also be necessary.
Huh?
Infrastructure will also be necessary.
Infrastructure we have
it's
it's
there.
available.
Available. And
But
more is
the
not.
technical manpower, because this is a continuous process,
Yes, sir.
some processing has to be done. We have now appointed one person, but the IT team was not did not exist earlier. Only in the COVID times we have now made it effective. We have upgraded our systems and all.
Right.
So we now need good manpower. The one which we are having, they are very good, but we still need better.
The exercise will be huge, man. That's
Hmm?
that's the exercise will be enormous. That's why the manpower will be more manpower will go by.
I was one of the initial takers of that computer education in 83-84. That time, basic and commercial basic, those languages were there. In Guwahati, there was only one institute. I was one of the entrants at that point of time. And now I'm a computer illiterate.
It changes every day, man. The technology
Huh?
rapidly changes every day, man.
Huh.
Every day is being upgraded. Man.
Now young boys and girls, they are doing far better in computers applications.
Surya Kumar Nigam. No, Surya Kumar. Well, just one thing, just like to say, my learning from this submitted.
Hmm.
Your
Yes.
Lordship, my lord,
Yes,
set the order of provincialization, my lord. For my benefit, my lord, page 64, my lord, and extra 20 of the second writ petition.
just read, do I have sent the file? Just
Well,
read
yes,
it.
I'll just read out. my lord. No provincialization order will be effected in case of schools having court cases in connection with appointment of teachers, dispute of lands, absence of Dias Code up to 2009, and others in conformity with the provisions of the Assam Venture Educational Institutions Services Provincial Service Act 2011 as amended. So the dispute, if it is with regard to appointment, my lord, dispute of land, my lord, only then the provincialization not be given effect.
Actually, the interpretation given by the High Court.
Right.
High Court has interpreted it.
Hmm.
You see that. Mr. D.P. Salia, Senior Counsel, Mr. Haris Lal, for the petitioner, Mr. P. Bora, for the Elementary Education Department, Mr. M. Datta, for the respondent number,
8, my lord, in the WC 117.
private respondent, number 8/9. Okay. Pass orders today, we uploaded only Monday.
Obliged. Deep level.
Yes, 8/9.
Look, in this case, Malad, R. Muzumdar is speaking, Malad, so Malad, some other than Malad.
He is not available.
Malad, he is in another.
Earlier, Lordship, he told me that he needs some time for produce the record. It was substantially prepared, so documents, one date. The date may be fixed, Lordship, in the time, let me produce.
Both sides are duly represented on the prayer made by Ms. made by the learned standing council for the elementary education department. Matters stands adjourned today. List on. With
In this month, Lordship, in this month. First month.
It did come after 3 weeks, my lord, any date after 3 weeks.
23rd May.
Lordship, I have a prayer in item number 9, 5219, Lordship. I learned from the learned council to the respondents that we made respondent number 6. We alleged some malafide against him. By name, we made party. He is no more. He passed away. His name is struck out.
In item 9.
Item 9, WBC 5219 2018.
Okay, what is his name?
Harendra Kumar Hajarika.
Okay.
He was earlier DA.
Okay. Here you add. The past two orders separately. In this you add. Upon instructions, Mr. S. D. Purkasal and counsel for the petitioner submits that respondent number
6.
6, namely Harendra Kumar
Hajarika.
Hazarika, has expired. Full stop. He
He was earlier former district elementary education officer.
was former district elementary education officer. And he was impeached by name because of certain allegations made against him. Hence it is submitted that his name is struck off. The prayer is considered and allowed. Name of respondent number 6 is struck off without affecting the seriatim of any respondents in this case. On the prayer made by Learned Standing Council for the Elementary Education Department, matters stands adjourned today. List on solicit.
Obliged, Lordship. Lordship, in part 2 item, I think learned council for higher education.
He is
is busy
taken
now next week. Similarly, the learned council, junior of learned council of UGC also, they have also paid for next week, Lordship.
Okay. We'll call in the next week.
58.
You will just remind the court officer, court master of the numbers, case numbers.
I can skip the part of this.
May I please, your lordship? Lordship, may have a look at page number 365. Of the education manual,
Our education manual.
366, sorry, lordship, the Assam Secondary Education Provincialization Service Rule 2003.
Yes.
The below, lordship, may I read, lordship?
Yes.
Lordship, substituted Rule 3 by the Assam Secondary Education Provincialized Service Amendment Rules 2012,
Yes.
published in the Assam Gazette Extraordinary dated 10th of July 2012,
Yes.
with effect from 10th of July 2012.
Yes.
So, lordship, what my learned senior submitted, that only came into effect from 10th of July 2012, and my case is before that, lordship. Now, lordship, have a look at page number 389.
Your cases of which year?
2011, lordship. The post was vacant Lordship, may I have a look at page number 25 of the writ petition. The post in question is lying vacant from the date 1st of March 2011. Assistant teacher.
Which serial number?
uh, Serial number, Lordship, 48. Due to the retirement of Sri Haripad Burman on 28th of February 2011.
Okay.
Now, Lordship, have a look at page number 389 of the education manual, the Assam Secondary Education Provincialization Service Rules 2003, Schedule 2, Lordship. The below of page number 389. Substituted Schedule 2 by the Assam Secondary Education Provincialized Service Amendment Rules 2012, published in the Assam Gazette Extraordinary dated 10th of July 2012, with effect from 10th of July 2012. Point number 2, Lordship, the minimum qualification for graduate teacher as well as language teacher should be graduate in art, science, or commerce. To be eligible to apply, a candidate must secure at least the second division either in HLC or in the higher secondary examination or equivalent examination and 40% aggregate marks in the BA. So the only requirement of for the post of graduate teacher is only graduation, Lordship. Before 10th of July 2012. And I am graduate, Lordship.
Yes.
There is a judgment of the apex court, Lordship. Page number 363. Paragraph number 22.1, Lordship. May I read, Lordship?
Yes.
The normative rule is that when a particular set of employees is given relief by the court, all other identically situated persons need to be treated alike by executing that benefit. Not doing so would amount to discrimination and would be violative of Article 14 of the Constitution of India, Lordship. So therefore, a similarly situated person was appointed to the post of assistant teacher. Therefore, I am definitely entitled for the appointment, Lordship.
Okay.
That's my submission, Lordship.
Okay. But Mr. A.K. Medhi, counsel for the petitioner, and Mr. R. Mazumdar, standing counsel for the Secondary Education Department, representing respondent numbers 1, 2, and 3. So none appears in call for respondent number 4, although notice is duly served. Next, Father. By filing this petition under Article 226 of the Constitution of India, the petitioner has prayed for a direction upon the has prayed for setting aside and setting aside of the impugn order dated 6/2/2015 passed by the Director of Secondary Education Assam within bracket respond number 2. Thereby refusing upgradation of the petitioner who is working as laboratory bearer in Borpeta Vidyapit HS School to the post of assistant teacher in the same school. Post of this petitioner is also prayed for a direction to the respondent authorities to initiate the process for selection and appointment of the petitioner to the post of assistant teacher at of the same school. Next paragraph. The case of the petitioner is that he is otherwise eligible for being upgraded to the post of assistant teacher of his school. Post of. The learned counsel for the petitioner has submitted that under similar circumstances, where a claim was made for being appointed to the post of assistant teacher the matter went up to the Supreme Court of India, and the Supreme Court in the case of Supreme Court of India, in the case of Subhash Chandra Das versus State of Assam and others, civil appeal number 10121 of 2011, decided on 24/11/2011. Took note of the rejection of claim by the authorities as well as this court. And it was held that the Supreme Court had, and it was held that and it was negated that the appointment to the post of assistant teacher under the Assam Secondary Education within bracket provincialized bracket post service rules for 1982 has to be made on the basis of direct recruitment only. And accordingly, the respondent authorities were directed to consider the case of the appellant for being appointed to the post of assistant teacher, subject to his clearing the selection test by the district selection board in terms of circular dated 17/4/1993. Full stop. Referring to the order dated 5/6/2013 issued by the Inspector of Schools, Barpeta District Circle, committee submitted that the Elementary Education Department, in compliance of the directions given by the Supreme Court of India, had upgraded the appellant therein, namely Sri Subhash Chandra Das, BA, laboratory bearer, Barpeta Vidyapit Teacher School, in the vacant post of assistant teacher of the same school. Full stop. It is next one. It is further submitted by the Learned Counsel for the petitioner that the provisions of the Assam Secondary Education within bracket provincialization bracket close service rules, 2003 was amended, which came into effect from 10/7/2012. Sorry, in this connection, it is submitted that the change of criteria brought about by the said amendment, which was made effective on and from 10/7/2012, would not affect the petitioner, as the vacancy arose in respect of the post of assistant teacher since 28/2/2011 on superannuation of one Haripad, HARIPAD, Burman, on 28/2/2011. In this regard, the Learned Counsel for the petitioner places reliance on Annexure 7 to the petition. By referring to the case of State of Uttar Pradesh and others versus Arvind ARVIND, Kumar Srivastava SRI VASTAVA and others, 2000 within bracket 2015, 1 SCC 347. has submitted that if one of the similarly situated person gets a relief by the court, all other identically situated persons need to be treated alike by extending that benefit. Otherwise, it would amount to discrimination and would be violative of Article 14 of the Constitution of India. First of all, para 22.1, on which Reliance is placed, is quoted below. First of all, per contra, the learned standing was for the second elementary education, the secondary education department has referred to the provisions of section, not section, it will be rule 2N and 2P of the Assam Secondary Education within bracket provincialization bracket closed service rules 2003. And it is submitted that for the post of graduate teacher, the candidate should have a minimum qualification of graduate. First of all, it is submitted that apart from graduate teachers, the said act also envisages postgraduate teachers. First of all, it is submitted that the provision of Rule 3 as introduced by the Assam Secondary Education within bracket provincialized service rules 2003. What did he say? Provision of rule 3, which has been brought about by Assam Secondary Education provincialized service within bracket amendment rules. Amendment bracket closed rules 2012. Was perhaps not brought to the notice of the Supreme Court of India. And that the proviso to the said rule, amended Rule 3 had made it clear that there would be no fresh recruitment to the cadres of junior teacher, junior classical teacher, junior Hindi teacher, senior classical teacher, and all such existing posts shall stand upgraded as graduate teacher or Hindi teacher having bachelor degree from any recognized university or classical teacher within bracket Sanskrit Arabic, oblique Assamese, language teacher, comma, as the case may be, bracket closed. From the date such posts become vacant either as a result of recruitment of existing incumbent or otherwise. Full stop. Accordingly, it is
Retirement. Retirement. Result of retirement.
result of retirement. Result of retirement of existing incumbent or otherwise. So it is submitted that it appears to him that the Supreme Court of India had proceeded with on the premises that apart from the graduate and postgraduate teachers, comma, there was a there was another category of post of assistant teacher. Post of. Accordingly, it is submitted that the correct law not being canvassed before the Supreme Court of India, or this the case of Subhash Chandra Das within bracket Supra should be treated as one which are decided on the facts of the said case and would not have a general application. First, it is submitted that a conjoined reading of Rule 8, 10, and the relevant entries of Schedule Roman 1 and Roman 2 would indicate that the post to which the petitioner is making claim can only be filled up by direct recruitment and that the candidate must satisfy the academic and other professional qualifications required, which also includes clearing TET examination. Facts are covered.
Yes, sir.
Okay, I'll just examine and pass orders today. We'll get it tomorrow. Not tomorrow, Monday at the latest. Okay.
Obliged.
part two hearing is item 55.
May it please your lordship, my lord, this matter related to my lord, the appointment of
No,
respondent,
you just have to wait for some time. Other respondents are where?
my lord.
Okay.
Now, my lord, it is abolished. Your lordship kindly see the director higher Madrasa education. Now it is no longer exist, my lord.
No, no, no. In item 55, there are respondents, other respondents also.
Yes, my lord. Sorry.
Mr. BC Das,
My
I
lord.
see his name. Just wait
And
for
then
some
even
time.
otherwise, my lord, matter is squarely covered in this point. This is involved in this case, my lord, already decided by the additional report, my lord.
No, that is okay.
My lord.
But since
My lord, yes, absolutely correct.
council like Mr. Das' name is shown.
My lord, sorry, my lord.
Madam, just show in the, that scroll in the list, item
55.
55. Take it
Yes,
up.
my lord, today we are not, nowadays we are not taking the cause list.
Ah.
So I don't know which, but I paying for the other side. Item number
Just
55.
scroll-
part to my-
Just scroll in the notice board, item 55, WBC so and so called. The respondents-
Definitely, because we are challenging the appointment of the private respondent. He has to
No,
be there.
somebody told me, I am not sure. Somebody told me that the that in your mobile, the display is not coming.
Yes,
Is it
my lord.
correct?
Absolutely, yeah, correct, my lord. And even in this display is only in campus only. If I staying outside, my lord, it will not be displayed, my lord. What is going on, my lord? That daily display, my lord. That display board is not available in outside.
Okay. Just wait for some time.
Yeah, my lord. Yes, my lord. Respondent number 10, my lord. BC Das, AR Siddhar, yes, AR Siddhar and Mr. Senior Advocate, Mr. BC Das.
You can ask her to find out if his
My
Siddhar is there. He sits in that
yes.
room below. If he's there, he can come.
I'll wait.
Mr. Sharma, you are otherwise prepared in this matter?
In this matter, R. Muzumdar will appear, my lord. This is Madrasa matter. So R. Muzumdar will appear. He is in like in put number 2, my lord.
Worker area network তারপরে ডিসপ্লে ইন্টারনেট এখানে আমি যেটু মারবো যেটু ইয়াতে নেটওয়ার্ক মানে ডিসপ্লে নিয়ে করতে আমি যে নেটওয়ার্কে কাম করে আমার ডিসপ্লে কাম করে internet को जो ठीक है नोटिस के लिए हाईकोर्ट ऑफ जिन्होंने प्रेजेंट
Mr. Mohanta, I am told that there is some institutional issue. We rely on the NIC. They have stopped transmission of the data in the local area network
My lord.
in the net.
Yes, and that I came to know. Yes, my lord. I inquired about it. I came to know. Yeah, that's why it is not
Because they are trying to protect our system from hacking.
correct. That is the reason, my lord.
They stated from NIC Delhi. This uploading,
Yes, that is.
uploading of what you call data from here to net has stopped because otherwise
Security reason, yes.
for security reasons. So anybody who is in the campus will get it,
Yes, you campus, he'll get it.
but outside the campus will not get that notification.
Ah, That's why there is a display, internet, there is a display in the board. That internet, intranet, not internet, intra. Earlier we are getting it, my lord, even in the outside, my lord, we get it in the mobile.
Huh?
Which item is going on, we easily can,
You can come from the comfort of your home also.
yes, my lord.
If your item
So
is
now that
late in
facility
the
has
day,
come.
that facility is not there. Let's see what can be done.
My lord.
Take it up
No,
with
if
the
it's
ICT.
security reason, my lord, then nothing, we have nothing to say. And that is good, my lord.
Because we are dependent on them, on the expertise of NIC.
My lord.
But I'll take up.
My lord.
This has to be taken up because this facility must be given to the lawyers.
My lord. That will be easier, my lord, that will be convenient, my lord.
That will be convenient, it will decongest the court also. You need not wait here.
My lord.
You can come in here. You can come comfortably. Mr. Das is coming.
Yes, sir. Sir, I'm sorry to trouble you. No, yes, if there is, there, your name is also there. Item number 55.
I don't have the instructions, my lord.
Okay.
He has not been contacted.
No, but still.
I was there in the court and therefore somebody.
No,
No, no, I'm not-
No, we are waiting for you because out of respect for you, we don't want to pass or hear matters in your absence. But we'll see if Mr. Sikdar comes up. We'll try to get Mr. Sikdar.
My lord.
But Sikdar possibly is not here today.
Okay.
He is
Not
away
here.
from.
Yeah, I have also not seen him today, my lord.
Okay.
He's not
Let
to
it
sit.
be given in the
As
list,
I
my lord.
know, earlier he told me that he will be away to somewhere.
Okay.
My lord.
Okay.
And let it be remain in the list, my lord.
It'll remain in the list.
Because
Okay.
I'm here, my lord. Yes, yes.
Okay.
Next week, any date, my lord, according to his convenience, my lord, I'll be. No problem.
Oh, yeah, Sikdar. Long back it was by. Odin Agotri.
Sorry, sir. কথাটা বলতে হয়।
16 matter, Mr. Das, you are right.
Yes, long back.
2016 matter. We are taking it up after 7 years. Definitely. you
By
need-
that, by this time, my lord, they have grown up.
Correct.
They can do it themselves. Sometimes 2010 measures are coming.
No, I may disagree with you. You see, as I am before you, to all the people who are in my family elderly to me, I am still that small boy.
Yes.
Even today,
Huh?
even today, my lord, small.
Even today. And the sad part is, when first my father expired and my mother expired then, one of my very good friend, he told me the same thing when my father expired and again when my mother expired. He said that now nobody is there to call you toy.
Yes.
Now, one gentleman told me, now you have become adult. So long you are minor, now you have to take your decision singly by yourself.
By yourself.
Yes.
So now, so therefore I disagree with you. They have grown up. We always have to bow down with, for what you call, the experience
Yes,
Correct.
which you have gathered.
I will
But this-
inform him, my lord.
There's no substitute for that.
That is, of course, sometimes, my lord. But I have crossed that age possibly. Anyway, I will inform you, madam.
Fine.
Next week. no?
Then I won't be taking up any other matters. I'll.
It is time also, but only, of course, half an hour left.
I'll rise because I have two matters which I have to conclude today. This incomplete orders. to save time in the court, I avoid dictating, but then I'll use my time there. Any other person ready? Both sides are ready in any matter? Mr. Das, you can leave. Then I'll rise.
এই order DCS করে চেম্বার যাব এতিয়া মই ছাৰক কিবা এটা সুধো ফটকে হৈ যাব আমাৰ কাম বিলাক টেনচন ল'ব নালাগে
ছাৰৰ মাতটো দিয়া নাই জামাতাৰে লৈ দিব দে এইবিলাক সিহঁতক কৰিব নহয় খালি কি চব কৰি যাওঁ এটা পানী গ্লাছত খাওঁ
এটা লেখা নাই না পার্ট টু দিতে লিস্টখানো
ও এখানে ছিল
মিটিং আছে
হা হা কিটো নাই নাই এইটো মই তেনেকে সেইকাৰণে তাক বেলেগে ৰাখিছো আৰু এটা কথা ৰবীন্দ্ৰ এই মই যে সদায় নবহো ন
next time ওই দিন দেখি